you get older, they give you rewards rather than an increase in your salary. First of all, I want to thank Laura and Ellen for inviting me here to Houston. I haven't been to Houston in 30 years. That's changed a lot, and it's nice to be back. What I'm about to tell you is actually quite depressing. I began my career, as Laura said, just as Gault was being decided. And over the past 40 years, one would think that life changed after Gault. That somebody turned the ignition on the car, somebody put it in gear, and the right to counsel emanated into the cosmos, and children began to have good lawyers. I could be very depressed. You know, Irene says when you get to be a certain age, you start to look over your career and see what you did. And in some ways, I could say I've been a totally abject failure. And what you hear later, as I go on, is going to tell you why I think I am a failure. But on the other hand, I look around, I see all these young, interested faces. I look at my former graduate student, Ellen, doing good work. And so I think I can retain the optimism that Irene talks about in the face of what we've come to know. Gault did not just spring fully developed out of the mind of Justice Fortas. When the case was decided, very few states actually gave the right to counsel to children. So in the aftermath of Gault, there was a flurry of legislation where every state actually changed its laws. There was a flurry of law journal articles because nobody quite knew how we would have a typical lawyer-client relationship between children, some as young as 9 or 11, people who we would never listen to or take advice from in the first place, and engraft the role of a lawyer, which is an agency role, as those of you who are in law school know, onto juvenile delinquency proceedings. There were a series of standard-setting groups: the American Bar Association, Institute for Judicial Administration, National Advisory Commission, Family Court Judge. Everybody was writing standards to try and develop the notion of what was the proper role of a lawyer. Prior to Gault, there was the best interest standard. Adults did to children what adults always do for children. We make their decisions and tell them what to do. Gault seemed to suggest the tables were going to turn, that the children were going to tell the adults what they wanted to do, and the adults would undertake that kind of representation. Needless to say, not everybody agreed with Gault. If you read the literature right after Gault, you would see this clash of ideas. And indeed, if you read the literature from as short a time ago as 6 months ago, you will see that this debate has not ended. There are any number of people who still believe, especially after Shaw versus Martin, that children are not capable of making decisions. The new brain research, which was undertaken in some ways to keep children out of the adult court, is working to our detriment because it's suggesting, well, maybe the agency role doesn't work here if these children cannot make these kinds of decisions. In order to understand, first of all, what's going on out in the countryside with respect to the right to a lawyer, we have to first know what is a good lawyer. Most of the people in this room, I assume, have gone to law school. I'm sure you believe that when you got out of law school, you had some sense of what a good lawyer did. Perhaps not, that your law school was very traditional. But if we look at the Code of Professional Responsibility, we look at the standards, we look at our ethical codes, we find some ideas about what lawyers are supposed to do. They're supposed to be knowledgeable. They're supposed to have adequate resources. They're supposed to inform clients of their rights and pursue investigatory or procedural steps necessary to protect those rights. They're supposed to interview their clients. They're supposed to interview police officers and witnesses, even when the client admits the client is guilty. They're supposed to be involved in pre-judicial activities as well as post-judicial activities. If the case goes to trial, they're supposed to present compelling and clear evidence on behalf of the child, cross-examine witnesses, and provide compelling arguments for acquittal. If the child is found guilty, the lawyer should actively participate in the disposition process. And as Ellen has written, and as everybody has said today, because our clients are children, we probably have a larger responsibility in each of these areas than if he or she was representing an adult. Interestingly enough, in the time of Gault, the decision in Gault, and 1995, we really had little idea of what was going on around the country country in terms of the right to counsel. If you lived in the District of Columbia where I live, we had a very sophisticated system. Everybody got lawyers. We had a public defender system. We had a fairly well-paid contract lawyer system. We had 5 law schools doing defense work for children. And if we just looked at the District of Columbia, we would say, yes, Gault, by and large, is being adapted. But in a few states that were studied, the evidence was not so clear. Excuse me. And so finally, between 1993 and 1995, the Bar Association did a small survey, interviews of about 200 lawyers, to find out what was really going on out there. The goal was not necessarily to condemn people or condemn states, but to just provide assistance for states that wanted to really implement the mandate of Gault. It was not a scientific survey. A lot of it was impressionistic. But at the end, they wrote a report called A Call for Justice, an assessment of access to counsel and quality of representation. And this is what they found. This is 1995. While superb representation exists in some jurisdictions, it is not widespread, and indeed it is not very common. They raise serious concerns that the interests of many young people in juvenile court are significantly compromised, and children are left literally defenseless. They reported that the defense bar had crippling caseloads, low morale, inadequate access to experts and investigative resources, that youth routinely waived their right to counsel, that plea bargains were being entered without lawyers, and that waivers of all these rights were not really knowing, intelligent, and voluntary as required by the Constitution. Well, this is pretty damning, but when we took these results to several state legislatures, they would say, oh, that's not us. This is what we do here in Pennsylvania. This is what we do in Texas. This is what we do in Indiana. That's talking about other people. So sometime around the year 2000, skipping history very quickly here, the National Juvenile Defender Center, which was a spin-off of an ABA group, began to conduct individual state assessments to see what was going on in the states themselves, so they could take this information back to legislators, judges, lawyers, and community members and say, this is what's really happening 40 years after Gault. 14 have been completed so far. Texas actually was one of the first, I believe, in the year 2000. There are 2 more that will come out this month. And of course, that leaves 34 left to do. 35 will become the District of Columbia. And what these studies have found uniformly, state after state, is that the assumption that children are getting good lawyers is not valid. First of all, children do not always have lawyers. And in Gault, one would think 40 years later, Gault says you have a right to a lawyer, that children have lawyers. First of all, parents who can afford to pay don't always do so, because they're often as angry as the court about their children's behavior and just don't want to deal with this. They walk away, or at a minimum say, lock them up for a few days and teach them a lesson. So not all parents will pay for the lawyer. When you look at those unable to pay, you find that the eligibility rules for appointment often discourage the appointment of lawyers. In Ohio, for example, they have a standardized system that does not look at individual people's resources. In Florida, you have to pay $40 for an assessment to find out if you're indigent. Well, where's that $40 coming from? And if you have $5 in the bank, you are not indigent. Fortunately, no one has a $5 bank account, right? You didn't know. So these parents, while they are entitled to counsel, counsel is not forthcoming. Most people use the federal poverty standard, but they use it at 200% or 300% or some percentage higher than the federal poverty level. You know the clients we deal with. These are not rich people, right? The rich people don't come into juvenile court. They go to a mental health facility that charges $40,000 a year. The kids coming into juvenile court are poor, and if they cannot meet these eligibility standards, they are not going out and hiring a lawyer. In Maryland, what we found was that 60 to 70% of eligible parents never met with the public defender in advance of the hearing, and if they did not meet with the public defender,